Welcome to this edition of IBFD's Tax Takes News and Views, bringing you the week's tax news in a nutshell. I'm Stuart Gibson, IBFD's Chief Editor, Global News in Washington, D.C. With me for our Beyond the News segment is Pasquale Pistone, Academic Chairman at IBFD in Amsterdam. On today's show, European Court delivers one win for Amazon and one for the European Commission. Australia's budget adds tax incentives for businesses, and Oklahoma targets more gig workers. These and more, including Pasquale Pistone's interview with Australian tax professor Miranda Stewart and Indian tax expert Mukesh Butani, coming up on IBFD's Tax Takes. First, we turn to the top news of the past week, as reported in IBFD's Tax News Service. Nearly 20 years ago, Luxembourg issued a tax ruling that enabled Amazon to shift the vast majority of its profits from an Amazon Group company subject to tax to one that is not. In 2017, as part of its state aid investigation into allegedly preferential European tax regimes, the European Commission ruled that Luxembourg's 2003 tax ruling, which the country affirmed in 2011, effectively granted 250 million euros in illegal state aid to the global giant, and ordered the company to repay the ill-gotten tax gains to Luxembourg. Last week, Luxembourg and Amazon scored a major victory when the European General Court overturned the Commission's ruling. After reviewing the tax rulings, the facts, and the arguments, the Court decided that the Commission had failed to prove that Luxembourg's rulings provided Amazon with a selective tax advantage. The Commission is considering whether to file an appeal. But the news was not all bad for the Commission last week. The same day that the General Court delivered a win for Amazon, it ruled that Luxembourg did grant 120 million euros in illegal state aid to French fuel supplier Engie when it selectively approved the company's intra-group financing structure, choosing not to apply a national anti-abuse provision. You win some, you lose some. In its latest budget, Australia seems poised to enact significant tax breaks for businesses. Effective July 1, 2022, the country will adopt a patent box regime under which income derived from patents will be taxed at just 17%. At the same time, Australia will introduce a corporate collective investment vehicle regime. Under that new regime, companies will be able to adopt a cellular corporate structure that allows flow-through tax treatment for each cell. In other business-friendly moves, the country will temporarily extend the period for loss carrybacks and temporarily allow businesses with total income of less than 5 million Australian dollars to fully expense their eligible depreciable assets. A reporter once asked the infamous U.S. bank robber Willie Sutton why he robbed banks. He retorted simply, because that's where the money is. Leaders in the Connecticut State Senate want to go where the money is to, in their words, overhaul Connecticut's fundamentally unfair tax system. To do that, they propose and call on their colleagues to support new taxes on high-income residents and a digital advertising services tax following the lead of Maryland. If they succeed, they plan to spend the new tax revenue to address funding inequities in the state's underfunded cities with low to moderate income minority residents. And Oklahoma legislators have found a creative way to cash in on the gig economy. Just as U.S. states and localities are finding ways to tax ride-sharing services like Lyft and Uber, that state has found a way to go after peer-to-peer car-sharing services like Turo. Starting in November, customers of car-sharing services in Oklahoma will have to pay a 6% gross receipts tax, regardless of where the car is registered. And now moving on to other news. Last month, tax authorities in Brazil ruled that companies outside the country that provide software as a service to Brazilians, referred to as SaaS, are providing technical services, and that payments for those services are subject to 15% withholding tax. This month, Chile ruled the other way, at least on income tax withholding. Chilean tax authorities will treat the SaaS technology as a license, which is not subject to withholding tax. On the other hand, the tax authorities ruled that the payments for the software license are subject to VAT. The taxman giveth, the taxman taketh away. In Denmark's first follow-up decisions to the famous ECJ Danish beneficial ownership cases, a Danish court has ruled in favor of the tax authority. The court agreed with the government's ruling that denied treaty benefits and the exemption under the parent subsidiary directive to two Danish companies that sought tax-exempt treatment for hundreds of millions of euros in dividends that they distributed to holding companies interposed between the Danish parents and their beneficial owners, all of whom were located outside the European Union. On very complicated facts, the court essentially ruled that because the dividends would be subject to withholding tax if paid directly to the beneficial owners, the companies could not avoid withholding taxes by simply paying the dividends to their intermediary owners. Perhaps most important is that in the context of interpreting the parent subsidiary directive, the Danish court essentially applied both the economic substance and anti-abuse doctrine, even though Denmark had not enacted either provision into its domestic legislation. And finally, speaking of beneficial owners, Russia will now require foreign entities to disclose information about their participants, including beneficial owners. Unfortunately, however, the penalty for failure to disclose is just 50,000 rubles, about $675. Time will tell whether companies will actually disclose their true owners or just pay the fine. And now we present a special Beyond the News segment to mark the launch of the second part of IBFD's Global Tax Treaty Commentaries, or GTTC2, analyzing tax treaty interpretations across a broad spectrum of countries. Pasquale Pistone, IBFD academic chairman and editor-in-chief of the publication, talks with two GTTC authors, Miranda Stewart from Australia and Mukesh Butani from India. Pasquale.
Thanks very much, Stuart, for your informative news report. Here today with us, we have Miranda Stewart. Miranda is a professor at the Melbourne Law School of the University of Melbourne. Miranda, thanks very much for being with us today. And let's try to focus a little bit more on Australia and the Australian bilateral tax treaties. Now, perhaps it can be interesting also for the ones who hear this interview to have an idea of what, in your view, stands out particularly, what features stand out particularly that indicate that the differences in Australia's approach to its bilateral tax treaties. So what are the specific clauses and what are the issues that arise in the negotiation, and what can we actually read in your chapter of the GTTC?
So, yeah, it's really interesting question with this project too, more broadly, is different countries really do bring a different approach. Although many countries rely on the model, the different approach is quite obvious. So writing the chapter for Australia, of course, there were some features about Australia's approach to tax treaties that I already knew, but actually working on the detailed chapter highlighted for me some particular elements. It's long been the case that Australia took a more, as I say, source-based approach. So that would imply a broader definition of permanent establishment, Article 5, sometimes a broader approach to the attribution of profits, net profits to the PE, Article 7 type issues, making sure, for example, about arm's length behavior, even among unrelated parties. Historically, Australia did not have a non-discrimination article in most treaties and did not support arbitration. We also might have had stronger or higher royalty rates, more similar to the UN model. These rules were all, these approaches to the tax treaties, the bilateral treaties, all were intended to protect Australia's more unique kind of approach. And I guess another feature is that Australia has actually fewer tax treaties than quite a lot of other countries. We have about 45 full bilateral treaties. In fact, we are moving towards a multilateral engagement through the MLI and the Convention on Mutual Assistance. And this is giving us a broader scope than we had historically, including adopting arbitration for the first time through the MLI and in our most recent couple of treaties. So I guess to summarize, the chapter shows the evolution over time of Australia's treaty policy. Even though we don't have a model treaty that we publish, you can sort of see the transition we are moving towards the OECD model, but still maintaining some of these unique features.
Yeah, that's very interesting, Miranda. Allow me for a very short follow-up question before we finish this interview, and that's related to the fact that some time ago when I visited you in Australia, I learned about the treaty between Australia and New Zealand, including arbitration, but with a limited focus. Now, you have said in this interview that Australia has strengthened its favor for arbitration in order to try and steer with the global standards. Has this affected the treaty with New Zealand, or is now New Zealand getting a more limited, scope of arbitration as compared to what you grant the other countries?
Yeah, so it is an interesting question that the New Zealand relationship might need to be updated. Actually, we have a very special relationship with New Zealand more broadly, economic framework. We reference it a couple of times in the treaty because it includes, in the chapter, because it includes a couple of specific rules about the competent authorities negotiating with each other to resolve disputes. So this is
Miranda, this is really very interesting. In my view, it's also interesting to see that if we look at what can be actually found in bilateral tax treaties, then we also more aware of whether, in fact, a country gives a separate treatment or a different or a better treatment to one of its most important partners. So I thought that this could also give a little flavor of why it is important to have a focus on bilateral treaties when analyzing tax treaties around the world. And Miranda, I would like to thank you very much for this interview. And to all of you, now stay tuned for my next interview with Mukesh Butani.
Thank you. Great to be here.
Welcome back. Joining me now is Mukesh Butani from New Delhi, India, and we are delighted to have him with us today. He's the founder of and managing partner at BMR Legal, New Delhi, and I think that Mukesh really needs no introduction. He's among the few acknowledged experts on international tax and transfer pricing. And Mukesh means India, and everybody knows him around the world. It's great to have him with us. Now, I would like to ask you, because you are doing theoretical studies, but you're also in practice. So, and you come from India, and I think that it's important also to have your own point of view on why it could be important for non-Indian academics and practitioners to pay attention to this case law, also when interpreting treaties that reflect the OECD Model Convention more closely. So what's your point of view, Mukesh?
Pasquale, firstly, thank you very much for having me, and I'm indeed privileged and honored to be contributing to the GTTC Pillar 2. To answer your question, we've noticed an exponential growth in the international arena with respect to relevance of tax case laws in the tax treaty landscape. IBFD has developed many tools, and over the years I can see more and more mention about India in many of those IBFD tools, which I didn't find it when we used to look at it earlier. Coming to the OECD and the UN commentaries, which are base documents that facilitate correct application and interpretation of law, and they also form the source for which the courts seek to interpret the law, have indeed played a very important role. However, practically most of the actual treaties do not look like the OECD or the UN Model Tax Convention, and at best sometimes they are an amalgam or a cocktail of these conventions, unlike what you see in continental Europe, where you strictly follow the OECD standard. And hence it's been an important exercise, particularly for me. I think the Global Tax Commentary is a single source of tax treaty interpretation, and I'm glad that India finds a mention over there.
So I felt it could be interesting for our audience also to see, what are the critical points arising from the perspective of bilateral tax treaties around the world, and in the Indian experience, what you think could be interesting to share?
Well, I think that there is general interest on jurisprudence that's evolving in India, and I had one of my judicial friends in Germany interestingly asking me for a particular Indian case that he wanted to refer to in a judgment. I thought that that was an extremely inspiring request that I had received. So the developments in the international case treaty law have been on a host of issues: beneficial ownership, permanent establishments, validity of a holding and intermediary jurisdiction, implications of GAR. However, we are seeing that specifically insofar as GAR and beneficial ownership is concerned, the jurisprudence is yet to evolve. So you will see many cases dealing with permanent establishment, attribution rules, and to some extent also specific anti-avoidance rule, but not for GAR or not for beneficial ownership. One, because the GAR law is new. Two, because insofar as beneficial ownership is concerned, we've had more focus on the concept of beneficial ownership in the context of exchange control laws or other forms of regulations that deal with offshore illegal financing, so on and so forth. However, having said that, when we look at some of the cases decided by the Canadian courts and by the Australian courts who follow the common law principle, I find that there is very little difference that approach that the Indian courts will take. For example, I see several common features between the Canadian, South African, and Australian GAR, though I feel as a criticism, India seems to have cherry-picked some of the best features that help the tax administration, not the taxpayers, from all of these regulations and supplanted them in the Indian law. I think the Global Tax Treaty Commentary will help in deciphering a unique model that is used by each country on interpretation of GAR, keeping in mind the overall treaty network. And I have no doubt in my mind that alongside that, the Indian jurisprudence on specific aspects of GAR and beneficial ownership will also get involved. But we see a fairly rich jurisprudence that available in the commentary if we look at the GTTC pillar.
Well, that wraps it up for this week's edition of Tax Takes, News and Views. We are very grateful to Mukesh Butani for this interview and for being with us. The week's tax news in a nutshell from our IBFD. I would like to say also on behalf of Stuart Gibson, thank you very much for watching us. And here is hoping your week is not too taxing. Goodbye.
Thank you very much, Pascal. Appreciate it. Thanks for inviting me.